Okay, let's talk about motions. Let me stop this thing. Motions. Most of us, we always hear all these. We don't want to file motions in our court cases, and we don't realize that motions are actually what helps move the courts forward, helping them do what they need to do. And I've been in the same position, saying the same thing. I stopped saying it for last past year, but I hadn't practiced using them, like actually filing motions, because we're just kind of going along with the same programming that I was taught online, where people tell you don't file a motion because then you asking them for something. You don't want to ask them for anything. When you want to demand something, and I'm like, my stance is not on demanding the court to do anything anymore. A lot of us are demanding in our cases are sitting still. Mine has sat still. You know, you sitting, got cases sitting still and not doing anything. They wondering why they ignoring your paperwork. And some people even file motions and they don't include the mechanics of the motion, as you're about to hear right here. It's telling you what it's for, what the motion is supposed to include. You know, all the different mechanics of the motion, and you're supposed to have these things put together when you're motioning the court to get them to give you an order on something, give you a ruling on an issue. So I'm gonna go ahead and start at the top right here. A written a written or oral application made to a court or judge to obtain a ruling or order directing that some act be done in favor of the applicant. Okay, the applicant is known as the moving party or the movant. Okay, so the movant is the one that's actually filing the motion. That's the one that's moving the court. Okay, in the United States judicial system, procedural rules require that most motions be made in writing and can require that written notice be given in advance of the motion being made. When motions specify they specify what action. Say written motion specify what action the movement is requesting and reasons or grounds for the request. Okay, that's plain English right there. Uh, a written motion can contain citations to case law or statutes that support the motion. This is why I tell you to read your damn statutes. Your state statutes they help you to move the court like you need to when you know what statutes in your state statutes support what you're saying. Look in your state statutes and see what you need to do or why you're trying to. You know, it explains the same stuff about a motion. Okay, and I like the fact that this is in plain English. You actually understand what it's saying right here. Okay. So you can use case law or the statutes to support your point, your grounds for why you feel like you should be granted relief. Okay. The motion also, say a motion almost always contains a recitation of the facts of the case or the situation prompting the movant to make the request. For example, suppose that the plaintiff in a lawsuit has refused to submit to a deposition, questioning under oath by the defendant. Okay, the defendant therefore files a motion with the court to compel an effort to compel the plaintiff to attend the deposition. The written motion briefly explains the nature of the lawsuit, describes the efforts made by the defendant to get the plaintiff to submit to a deposition, addresses any known reasons for the plaintiff's failure to cooperate, and recite the statutes that permits the taking of depositions in civil litigation. Okay, the motion may also request that the issue be addressed at a hearing before the judge with all parties present. Once the judge receives the motion, he or she may grant or deny the motion based solely on its contents. See, most people when you file a motion, you don't have any contents attached to it. I mean, you don't have any contents in there, like as far as what they just told you to put in there, right here. You don't have any of that in there. You're just really just trying to get them to do something, but you don't explain the grounds for the motion. You don't have anything to back up why you're saying it. You don't have any evidence to prove anything. Like a lot of people have made created motions and they're stating what they deem to be facts, but they're not. They don't have any evidence to prove the facts. Okay, so if you have evidence, you should be attaching that to your motion as well. Okay, so whatever it is that you need to move the court with, that's what you need to use those motions to help move the court like that. Under some circumstances, motions can be made orally. Oral motions frequently occur during trials when it is impractical to draft a written motion. A common oral motion occurs during witness testimony. Witnesses sometimes give inadmissible testimony before an attorney can object. They do it before an attorney can object. When that happens, the attorney must object and move the court to strike the inadmissible testimony from the record. Motions for mistrials made when courtroom proceedings are fraught with errors, inadmissible evidence, and disruptions so prejudicial to the party's case that justice cannot be served. Often are made orally. Sometimes judges themselves take action on behalf of the party, such as changing or adding necessary language to a pleading without a motion from a party. This is known as making an amendment on a court's own motion. The motion a motion to dismiss ask the court to dismiss an action because the initial pleading or complaint fails to state a cause of action. Let me click on that real quick. I think I might want to go in there real quick. Let me see. A motion to dismiss asks the court to dismiss an action because the initial pleading or complaint fails to state a cause of action or claim for which the law provides a remedy. Cause of action: the fact or combination of facts that gives a person the right to seek judicial redress or relief against another. Also, the legal theory forming the basis of the lawsuit. That's good. Okay, let's thought I'd back up on that real quick. Okay, now a motion. Did I read the whole thing? No, I didn't. Okay. For example, a complaint alleges that an employer unfairly fires. What the hell? Unfairly fires an employee, but does not allege illegal discrimination or labor practices. Merely firing an employee for unfair reasons is not illegal. Thus, the court may dismiss this complaint. Okay. A motion to strike asks the court to remove from a motion to strike asks the courts to remove from the record inadmissible evidence or language in pleadings that is redundant, immaterial, impertinent, and or scandalous. A party can file a motion for more definite statement than when the language in a pleading is so vague or ambiguous that the party cannot reasonably be expected to draft a responsive pleading. That's that's crafty. I didn't think about that part. Somebody send you a summons or whatever, and they want you to answer some shit, and they got vague language in there. You don't know what it is. You don't know what the hell they mean. They're using all types of ambiguous language in there. I used to talk about that last year, but I'll let y'all use that how you need to use it. But you see exactly what it's telling you. Okay. A motion for summary judgment, also known as a motion for judgment on the pleading, asks the court to make a judgment solely on the facts set forth in the pleadings, without the necessity of trial. A court will grant a summary judgment motion when the material facts of the case are not in dispute, and all that remains to be determined are questions of law. For example, in Steiber versus Journal Publishing Company. Okay, the court found that the issue of whether the newspaper company's treatment of the reporter was extreme and outrageous was a legal question, not a factual question. Okay, in that case, the reporter Tamar Steiber sued her employer for among other things intentional infliction of emotional distress. Steiber charged that the newspaper asked her to write so that many daily stories asked her to write so many daily stories that she could not perform her duties as a special projects reporter. To recover for her for the tort of intentional infliction of emotional stress, the court noted Steiber had to prove that the newspaper's conduct was extreme and outrageous as to go beyond all possible boundaries of decency and to be regarded as atrocious, and utterly intolerable in civilized community. The court ruled that as a matter of law, Steiber failed to prove this allegation, and the lower court's summary judgment was affirmed. Okay, let me see. Um, a motion in enlightenment. I never heard of that. A motion in enlightenment, also made before trial, asked the court to prohibit an opposing party from offering evidence to or referring to matters that would be highly prejudicial to the movement during a trial. A motion to suppress a motion to suppress is similar to a motion in Lyman, but asks the courts to keep out of a criminal trial evidence that was obtained illegally. That's all fruit of the poisonous tree. Remember, we talked about that before. Usually, I'll probably make another video about the fruit of the poisonous tree and repost it. But it won't be the old video because I don't know what I said in that video. Anyway, usually in violation of the Fourth, Fifth, and Sixth Amendments of the U.S. Constitution. For example, a defendant in a murder trial may move a court to suppress her confession because she was questioned without being told of her rights to have her attorney present. Following the trial, but before the a jury verdict, the party may move for a direct verdict, asking the judge to make a judgment without letting the jury reach the verdict. Following a jury verdict, the party may move for a judgment notwithstanding the verdict. This motion requests that the court enter a judgment contrary to the jury verdict, and is granted when no reasonable jury could have reached that verdict. A motion for new trials. A motion for new trials. Hold up. A motion for a new trial asks the judge to order a new trial, setting aside the judgment or verdict because the trial was improper and unfair. Okay. A motion for a new trial. Okay. This motion is sometimes brought as a result of newly discovered evidence. Okay. So you see the different types of motions you can have right here. Different types of motions. Let me read this part right here too, and then I'm gonna shut it down. Let me see. A formal request made to a judge or for an order or a judgment. Motions are made in court all the time for many purposes: to continue, postpone, or trial to a later date, to get a modification of an order, for temporary child support, for a judgment, for dismissal of a opposing party's case, for a rehearing, for sanctions, payments of the moving parties, person making the motion. Let's see, cost or attorney fee. That's when they're trying to do that. For, let's say, for sanctions, cost of the attorney fees. Okay, sanctions, payments of moving parties, person making the motion, cost for attorney fees, or for dozens of other purposes. Most motions require a written petition, a written brief of legal reasons for granting the motion, often called points and authorities. Written notice to the attorney for the opposing party, and a hearing before the judge. However, during a trial or a hearing, an oral motion may be permitted. Okay, I said all that in this here. So you should already, should have a good idea, how to put together a motion. If you have those mechanics written in that, put together in that motion, then you have a motion. I'm gonna show you another part too. I like U.S. legal. U.S. legal was pretty. Let's see if I can come on back up. Okay, where's USlegal.com? They stated in one time. Where is that damn thing at? Hold on a second. I'm gonna pause this real quick. I'm gonna find it. Okay, that's what it was. Rule 47. Motions and supporting affidavits. Let me show you something. This is what I was talking about on the affidavits right here. Pay attention to letter B right there. I'm gonna start with A. In general, a party applying to the court for an order must do so by motion. Okay, it tell you, say you must do so by a motion. You got to use a motion. A party applying to the court for an order must do so by motion. So you can't get them to do any orders. You can't get them to do any orders if you don't use a motion. You choose not to use a motion, your shit gonna sit there. They're gonna deny your shit. They're gonna keep fucking with you. Okay. It said must be. It didn't say can be. It said must be. Must do so by a motion. That's Rule 47. Form and content of a motion. A motion, except when made during trial or hearing, must be in writing, unless the court permits a party to make a motion by other means. A court must state the grounds on which it is based and the relief or sought. See, I'm going to read that again. A motion must state the grounds on which it is based and the relief or order sought. Okay? And it says a motion may be supported by affidavit. That's why I say you got to have your evidence. An admissible affidavit. An affidavit, that's evidence. If it's done properly, it could be, it's admissible evidence to attach to your motion, so that you can actually get them to move on the court. And you can actually use affidavits, different types. Affidavits can also have what to say exhibits attached to it. I always advise that exhibits be attached to an affidavit as well, because if you have you stating something under swearing under penalty of perjury. If you have evidence to prove what you're swearing under penalty of perjury, that makes it even better. It's even more solid. And if you have two witnesses to sign that affidavit, to write on there, or you can have it, a way where they can sign under penalty of perjury, swearing under penalty of perjury, that what you're swearing under penalty of perjury is the truth, to the best of their knowledge. Then now that's a maxim of law. Every word shall be established by two or more witnesses. So that's a maxim of law. That's what gives your affidavit even more weight. Okay, because you have witnesses to prove what you're saying. They're signing off on it as well. Okay, or you can have them do the same. You can have them do an affidavit. If you choose to do so, you can do it that way, and all three affidavits. All three affidavits are attached to your motion. But that's what's going to support your motion. You have affidavits or evidence attached to it, whatever, to prove what it is that you're saying and why you feel like you should be granted relief. Okay. Now, C, timing of motion. A party must serve a written motion other than one that the court may hear ex parte, and any hearing notice at least 7 days before the hearing date, unless a rule or court order sets a different period. For good cause, a court may set a different period upon ex parte application. Okay, and D, and I'm gonna stop right here. Affidavit supporting motion. The moving party must serve any supporting affidavit with the motion. A responding party must serve an opposing affidavit at least one day before the hearing, unless the court permits later service. Okay, it tells you right there. The moving party must serve any supporting affidavit with the motion. So when you just file a motion and it's just by itself and you're just stating what you want to say, and you just file it in there, and they just do what they want to do. No, you're not following the rules. You have to find out what a motion consists of, how to file it, what you need to have to support your motion so that you can do it correctly. That way you can get them to move. It's all about learning how to play the game. It's all they're doing. They have rules already set in place. We can't sit here and say it's their stuff. When you try to make up our own stuff and thinking we're going to make up our own stuff and they have to respect it. No, you have to follow the rules. They got these rules put in place so that there's order. You got law and order in the court. You got to have order in the court. So when you're following the orders, the rules that are put in place that'll help you get your remedy, then that's how we're going to get the remedy. Rule 47, it tells you motions and supporting affidavits. And it tells you in plain English, letter D, say the moving party must serve any supporting affidavit with the motion. It told you what the motion is supposed to have in it, and it tells you that you have to have an affidavit of supporting what it is that you're doing, what it is that you're trying to get done. You can't just file a motion by itself and expect them to grant what you're trying to get done. File it with attach your affidavit, attach your evidence to it, and then you can get your relief. Okay. All right, y'all. That's it for today. I did 3 videos today. I think I'm gonna sit my ass down for a minute and concentrate on getting my stuff done today. I got some more stuff I got to do for myself. All right, and we'll get with y'all on this go round. M. Rose signing out.